Welcome to Podcast with Ola. This is the second episode, and I'm so glad to have you here. I'm so glad that I jumped on that your collaboration post on Instagram. So, yes, viewers and prospective viewers, viewers, let me just say how I got this guest was that I was going through Instagram and he had made a post about collaborating in 2022 that, lawyers, professionals generally, that there's more benefit in collaboration than competition, in 2022. So I immediately jumped on the post and said, I'd love to collaborate with you. Would you come on my channel and speak about, a legal topic of your choice? So I think that was in very early January, and we were able to agree on today. So I'm glad that today has finally come, and we're going to be delving into intellectual property. So let me read out his bio, which is very, very impressive, I must say. So today we have with us Mr. Seyi Arowosebe. Is that the correct? What's the pronunciation, please?
Okay, the person is Arowosebe.
Okay, it's not even what I thought.
Arowosebe.
Don't worry, I'll ask you for the meaning much later. But okay.
It's all right.
Seyi holds a Master of Laws degree in Intellectual Property Law and Policy. Is the principal partner at Dilex Consult. He's an alumnus of the Lagos Business School, University of Ado-Ekiti, Nasarawa State University, and Nuru, USA. He was called to the Nigerian Bar in 2014 and started his professional career as a lawyer in the law firm of J.S. Okutekpa SAN and Co., where he was exposed to litigation in all the superior courts in Nigeria. In 2017, he established Dilex Consult, a corporate and intellectual property law firm, which has helped hundreds of clients in the formation and maintenance of corporate entities, and also safeguarding the copyright, trademarks, patents, and designs of individuals and corporate entities. She is a consultant for Citizens Gavel, a civic tech organization accelerating the pace of justice delivery through technology, access to justice, and citizens' engagement. Among other programs, Gavel offers pro bono legal services to indigent persons, victims of all forms of abuse and brutalities, and awaiting trial inmates in various correctional centers across the country. He is the legal advisor to the Fellowship Abuja Initiative, a network of young Christian professionals, entrepreneurs, and creatives. He's also the legal secretary of Every Child is a Star Foundation, a nonprofit that caters for the welfare and well-being of underprivileged children in the society. She is happily married to Oyebimpe, and they are based in Abuja, Nigeria. She's a lawyer too, right? So
No.
She's not a lawyer. I really
didn't marry.
I really thought she was lying. His activities we'll share his handles much later. But I know that from what I've read, you can see that we have the best hands here with us to talk to us about intellectual property. I think that when we initially started talking on social media, I think it was that Citizens Gavel something that really caught my attention. I was even hoping that maybe you would like to come and talk about police brutality, how you people release people, because I think that's what you do, right? But maybe if
we can always schedule another conversation.
For that, because that's one area of curiosity for me. So we can see that he's a very seasoned legal practitioner with so many feathers to his cap. Make welcome today with me, Mr. Seyi Arowosebe. When viewers watch, they will clap for you. So we're going to go.
Thank you so much for having me.
You're welcome. We are going to go straight into intellectual property. Now, the aim of this session is to try to do an expose on intellectual property law in Nigeria, so that the layman would have a correct picture of what it is about and, the developments and the prospects of intellectual property in Nigeria, and so that the law students, can be able to get their minds, expanded on the subject matter, in case they want to go into that area of law, and so that the lawyer can even avert their minds or get a refresher course, in intellectual property. I know that it's an area in Nigeria that still needs a lot of development, and I'm really glad that it's getting a lot of traction, much more than before now. So we want to talk about it, to call attention to it, and to ensure and hope that maybe one or two persons will benefit from this, and will be able to secure their own intellectual property. And if a lawyer might be able to decide, oh, let me just go into this area, and of course, so that people can understand that our guest today is like a very good hand, when it comes to intellectual property. So for people that would like to take the conversation further, if you would just watch till the end, we are going to share his social media handles and his contact, so that if you want to contact him, for intellectual property law services, you would understand exactly what he does, what his specialization is, and how he can render services, be of help to you. So I'm going to ask Mr. Seyi to do for us an introduction generally into intellectual property. So when we talk about intellectual property and intellectual property law, what exactly are we talking about?
Thank you so much once again for having me. So when we talk about intellectual property, please permit me to use an acronym for it, IP. So anytime I say IP, just know that I'm referring to intellectual property. So when we say IP has to do with various forms of work of the intellect. These are content that emanate from mental thinking, from intellectual thinking. So they can form a form of scientific, literary, artistic, or whatever. So anything a man can conjure in his mind, and then you express in whichever form you want to express it. So is it a song? You first of all conjure the lyrics in your head, and then you find the melody to it, and then you sing it out. It becomes a song. Is it a poem? You create the content, the lyrics, the wordings, and then you write it, and then you publish it. That is IP for you. You think of a way of maybe creating a machine. You discover that all the pounding machines you see in the markets are not good enough. You just devise a new way of creating a pounding machine. That is patent right now talking. So anything we can think, we can create, and then we can bring out to which people can feel, understand, and make use of. That is IP. It can go diverse ways to describe IP. Basically, it is things that we can conjure in our mind and we can bring out for people to see, to feel, to use. So that's just the basic introduction to IP I can give.
Maybe you could talk about the branches, the various branches, before we narrow it down. I know that in Nigeria, where the most prominent ones are copyright and trademarks and patents to an extent, but just talk about the branches a little for people who do not even have an idea of what the branches of intellectual property.
Branches now, the forms of trademarks, talking about industrial design, talking about patents, and then in some instances, talking about geographical indications and then plant varieties. So just give a background to the things I've just mentioned now. Copyright is probably the commonest of all forms of IP. As you are sitting right there having this conversation, if you look behind me, you see on the wall. This on its own is copyright, That is one. So copyright, the songs, the music, the books, the maps, the various things that people can relate with. The novels of this world, the poems, your post on Instagram, on Facebook, these are copyright. So you have copyright in them. So what is copyright really? Copyright is those rights that emanate from literary works, artistic work, the right that the owners, that the authors of this work have is copyright. The next of them is trademark. Trademark has to do with words or symbols that identifies a particular product or service. Something that describes your business, something that describes you as a brand, as a business person. For instance, everyone seeing this video will be seeing it from the comfort of their smartphones or their computers.
Mm-hmm.
Now, those gadgets have been made by somebody. If you check the back of your laptop now, you can see HP, you can see Lenovo, you can see Dell. So those the names, the wordings and the images of those the brands on those gadgets are trademarks of those people. When you see an iPhone, you see Apple at the back. That is the trademark of Apple Incorporation. Okay. So that's for trademark. Trademark could be the name, the trademark, you could trademark the name or have a symbol that distinguishes your business, your service from that of others. So that is trademark. We have patents. Patents are the rights that are accrued to inventors. When you devise a new way of doing something, perhaps you discovered a new food recipe, discovered a new way of making. I mentioned earlier machine. You discovered a new way of making a machine that pounds yam maybe better or faster than all the pounders that you've seen out there. So if we can get patent right for that. We have industrial design. This is a combination of lines, the actual feel, the Ankara that we see, the patterns. Those ones are industrial designs. The bottles of Coke that we see is an industrial design on its own. Okay. Then I talked about geographical indication. This one has to do with things that emanate from a particular place. The easiest example I can say now is Gari Jebu. We all know Gari Jebu.
That's our own.
Gari Jebu is exactly. So Gari Jebu is peculiar to the Ijebu. So if anybody tells you I have Gari Jebu, by the time you taste that Gari, you'll be able to tell whether or not it was actually made from Ijebu. You will know whether no, this Gari must have been done in Ibadan or somewhere else. Because Ijebu Gari is just peculiar. You would know it is them that have it. And then I mentioned about plant varieties. These ones are just advanced forms of IP. I don't need to go into this for the purpose of this conversation. These are the 6 forms of IP that we can lay hold on at this time. Assures that IP continues to evolve, it continues to grow. No limitation to it. There's so much. Thank you.
Thank you so much. So let's talk about copyright now. Let's narrow it down to copyright because that's like the most common form of intellectual property in Nigeria. Everybody's throwing the word around. I'll sue you for copyright infringement. I'll sue you for this and that. So let's talk about copyright itself. What is copyright? Who can own a copyright? How are my works copyrighted or copyright protected? The nitty-gritties of copyright.
Copyrights are those rights that are accrue to authors, owners of literary work, artistic works, musical works, songs, maps, and the like, cinematography, sound systems. So the right that the owners of this work enjoy is copyright. Okay, so how did you come about having this copyright? I mentioned earlier that IP is basically the content we have conjured in our head and then we manifest. So manifesting this work alone gives you copyright. For instance, when you write a book, the mere fact that the book is published, there is copyright protection on that book. Okay, it's as simple as that. You don't even need to go to Copyright Commission to register that book before you enjoy copyright. Although it is advised that after the publication of any book, you should take a copy, apply at the Copyright Commission for registration. But even without doing that registration, the mere fact that that book has been codified in a single document and it is published now, either in hard copy or in soft copy. I said earlier that your post on Instagram, on Facebook, enjoys protection, enjoys copyright protection, because it has you've taken it from the realm of just having it in your head as an idea. You have expressed it. You can feel it. We're not feeling it in your head. You can feel it in a place where you have published it. And we can ascribe ownership. We can ascribe authorship to you. So you enjoy copyright protection on that. When you sing a song, exactly, you sing a song. The moment that song is mixed, is arranged, is mastered, and then it's published, it's streamed. You can listen to it on YouTube, on all the streaming platforms. There is copyright protection for that song. The moment you publish a poem, for example, a poem of 6, 7, 10 lines on any medium, on any platform, there is copyright protection on that. This makes copyright the easiest and the simplest of all forms of IP. Now, you cannot take it a step further by registering it at the Copyright Commission. Perhaps you foresee that there may be issues of litigation coming up in the future, or you already foresee that somebody is going to be infringing on this your copyright. take it a step further, register it at Copyright Commission, and then get the certificate. And then when time comes, you can always brand new certificate. Oh, I register my copyrights for this book this year at Copyright Commission. But you're not foreclosed from claiming any rights at all, damages or whatever, when there's an infringement. That means even without registration of your content, of your work, you can still enjoy, can still claim damages for infringement. So that is for copyright. Who can own copyrights? Anybody whatsoever can own copyrights. You know, the copyright does not know age, does not know race, color. And the good thing is that a natural person can own copyrights, and actual person can also own copyrights. So a company can actually own copyrights. So a book can be published in the name of a company. For instance, when a company publishes a report, so the copyright in that report accrues to the company. It doesn't need to accrue to members of the company in their individual names. So a company can have copyright. However, there's a difference between the duration of the rights in copyright when it's a human being that has it, and when it is a government body or a corporate body that has that copyright. I should also say that the duration of protection of various forms of copyright differ from one another. You know, just like have the musical work, the artistic work, and literary work that enjoys the longest term of protection. Okay, and one of my very quick examples is Things Fall Apart by Chinua Achebe. Let me just establish this, that literary works, artistic works, and musical work, they enjoy copyright protection for 70 years from the end of the year in which the author died. I'll say that again. Literary work, artistic works, and musical works enjoy copyright protection throughout the lifetime of the author, and then 70 years after the end of the year in which the author dies. So, for example, now, Chinua Achebe wrote Things Fall Apart in 1997, right? And then Chinua Achebe passed on to the world beyond in 2013. So Things Fall Apart as a book continues to enjoy copyright protection as from 2014 for another 70 years. So the estate of Chinua Achebe continue to reap economic benefits for copyright protection for that book for the next 70 years. So which means copyright protection subsists for another generation after the lifetime of the author. That is so massive, so massive. So that is that for literary work, artistic work, and musical work. Now, the other forms of copyright, we have cinematography films, we have broadcasts, and then we have the seventh one now. Those ones enjoy copyright protection 50 years after the year in which they were created. Exactly. So let me make this disclosure now. I mentioned about literary work, artistic work, and musical work that there is a 70 years protection from the end of the year in which the author dies. So when it is a government body or a corporate body that owns copyrights in that book, in that song, or in that artistic work, there's copyright protection for 70 years from the end of the year in which the work was first published. So that is the thin line between copyright that is owned by a natural person and copyright that is owned by a government or a corporate body. Let me know if I've answered all the questions in this last line so that I can respond to them.
Okay, so if I get you correctly, what you have said now is that for copyrights owned by a person, it's 70 years after, that's for literary works, artistic works, and mystical works. That's 70 years after the death of the person. So for instance, Shakespeare's works, I think it's been 17 or over 17 years since he died. So they are free from copyright protection now, and anyone can use them without consequences. But if it's a government work, 70 years from the date of first publication. Is that correct?
Yes.
Okay, so I'm assuming that's because government never dies, and government is a corporate. Government is a corporate entity. Yeah. So yes, I think that if we were to go into related rights, fair use, and all of that, it would take us too much time. But I've done a few videos actually on the channel about copyright, related rights, fair use, trademarks, and what have you. But it's good to hear from someone else's mouth. So we've talked about who can own copyright. We've talked about protection for copyright. So let's talk about why is copyright. What use is it that I have copyright over protection over my works? Like, what does it do for me? What does it do for the society? And what does it do to people who are seeking to exploit, my copyrighted work?
This belief that the creator of works should enjoy the economic benefits that follow those works. For instance, as an author, I spent the last 3 years researching, gathering data, content, in publishing a book, a 780-page book. So, and a copy of this book is selling for 10,000 naira. It is expected that all the effort that has been put into this book must be reaped financially. Of course, the publishers will get their own pay, the researchers who help to get their own pay, and even me too. The fact that my brain has been put to work for a number of years, researching, proofreading, editing, drafting, and a whole lot. So there is need for me as an author, as an owner, to enjoy the economic benefits that accrues to that work. So it is unconscionable for anybody to pick up that book and start infringing on it. So this is the reason why there is protection for copyright, for the authors. The work must be protected. It is important. It is important. However, the public also deserve a right to use that work. But in their using the work, they must not infringe on the rights of the owners of it. They must be ready to pay value for the work. Although we have exceptions to copyright infringement, which I will delve into briefly. You rightly mentioned fair use. Yes, you can take a little portion of a work and create another work with it. But don't forget that there is need for you to acknowledge the owner, the author of whichever work you are using fairly. And then there is provision for research. You can, of course, you can do research with the work of other authors, but there is also need for you to acknowledge, to mention, to give kudos to the work that you are using. This will take us to plagiarism test for university dissertations that we write. When you write a project, you must have consulted a number of books. So, of course, you have to give a list of all the books and refer to them where you use them. So when you fail to acknowledge the books you used in your work, plagiarism will catch up with you, and this actually attracts a whole lot of sanctions in schools. Like saying, people lose their titles, their professorship, their doctorates because of plagiarism. So there is need for the owners, the authors of copyright work to enjoy the economic benefits that accrues to the work. But the public should also not be short, should not be blacklisted from enjoying the content of that. When I write a book and I publish, it is for my economic good, and then for the public consumption. The public should learn. They should learn new ways of doing things. They should see my idea about a particular topic that I've written on. Yes, I hope that answered.
Thank you so much. So there's something that I always say on this channel, that nullum simile est idem. Nullum simile est idem. That is, nothing similar is the same. So for copyrights, you find that, especially, I'm saying this because, you talked about writing a thesis and citing, bibliography and what have you. So you find that sometimes you have written something, and when you want to cite it, or when you're making your research, you find that someone else has written it. It's almost the same. But you're thinking, I didn't read this person's work. I wrote it from my head. So really, how will I put it? How do I demarcate or delineate the originality of my copyright? Like, is there like a first in time rule, or how do I know that, oh, this thing is my own copyright if someone else is laying claims that I did it first, and all of that? So can you maybe shed a little light on that?
So I mentioned earlier that copyright exists in a work the moment you can build the work. The moment you take it out of your head, you publish it somewhere, there is protection for it. So if that idea is still in the head of anybody, then nobody can lay claim to it. You'll be able to lay claim to copyright in a work when you can show us where it was published or when you registered it. So if I wrote a poem today and if I publish a poem today on Facebook, and somebody comes and say, "Oh, you copied my poem, you copied my wordings, you copied my own poem word for word," the question I would ask such a person is, show me your publication first, or show me your registration. Two things: either you show me where you published it, or you show me when you registered it at the commission. And I can bet there's no way two poems will be composed with similar words, with similar punctuations, with similar topics, without opinion.
So there has to be some level of difference.
Yes, I want to assure you that if we both witnessed a scenario today, by the time we are reporting that incident, our narrations will be different. There will be differences. Of course, there will be similarities. Perhaps in a major event, maybe the president came to the stadium. Of course, that won't happen. But the way I would narrate the coming of the president, the way I would narrate the way it was received, will be different from the way you will narrate it. So there will be differences in our narration. There will be differences in our storytelling. But when you see that the contents are 100% similar, something is fishy. But I would want to know where the first publication was done, such that so the moment there's been no publication, then it means the claims you're making is just baseless. So the first to publish or the first to register, whichever one avails you at that time, is the one that has protection in that copyright. So if you are claiming that somebody has infringed your work by way of copyright, please be ready to show us where you published it or when you registered that work. Very important. Very important.
This reminds me of that Alexander Bell or the Wright brothers. Those ones that made the telephone, they said that one was, that's patent though, that one was running, to the courthouse, and then one got there before the other. So, first in time. So, yeah. And I think that now that we've touched in this area, it's making me think about plagiarism and copyright. They're two different things. And then I'm also thinking about song sampling and copyright. They're also different. I have all these videos on the channel. I'll leave the link to them in the description box. But what I'm saying is that they're also intertwined. So for instance, the question that I just asked you, I'm thinking of a scenario whereby maybe I've listened to a song, but I've forgotten about it, but my subconscious has, registered it. And then maybe in the next 10 years, I'm trying to produce my own song or sing my own song. And now I'm referencing or using that song. And I'm saying, I didn't copy anybody. I didn't even know that this song exists or blah, blah, blah. So I would ask later, the role of a lawyer. But I think that essentially what I can bring out of this is that when you want to exploit copyright for commercial purposes, you have to be extremely careful. And, you need a lot of people, there are producers, there are recorders, there are, people that will just fact check for you, and then lawyers, so many roles, because all these people have to check these things for you. And I think that the entertainment industry, they have this challenge the most. I remember that I think towards the close of the year, last year, this song, this popular Dorime, you want to bam bam, or that song, what's the name of the guy? I think it was pulled off the streaming platform because he had sampled the original Dorime song and did not get clearance from the owners. So, but I think they've settled it and it's gone back. But we'll talk about that. We'll talk about the role of lawyers, in clearing all these things so that, you don't get yourself mixed up in all of this. Another area I'm thinking of is copyright in the workplace. It's so, copyright is so, when you talk about it, it looks so simple. But now when you start to talk, it's the kind of topic that begins to expand itself. Because now I remember that G case and ShopRite issue. The journalist wrote about last year, how he produced this song for ShopRite, and then there was this clash. And I saw how even lawyers interpreted copyright and the ownership. And so I think that as simple as it is, it's not that simple. It's something that you need to, get a professional, someone that really understands, that really knows their onions to do for you, because you can get it mixed up at any point in time. So before we move to trademarks, let me just ask all the questions on copyright now. So if perchance I find that my copyright has been infringed upon, or I know that you said that it's protected once it's created, but if you want to be double sure, you can register it. Yeah, just so that, if there's a problem, you can immediately bring up the issue of registration, first registration. So if I find that, or I suspect that my work is being infringed upon, what's the first step for me to do as a copyright owner?
Okay. So if you observe that copyright is being infringed by somebody, it is advised that you take the gentleman approach and start. You can write a letter of the system to the person to stop all actions in that regard. Okay, and when they refuse, when they fail to take your gentleman approach, then you can consult a lawyer to sue for you. There are various remedies that are available for somebody who is claiming that his copyright has been infringed. So when you go to court for instance, you can be suing for damages. You can sue for damages, punitive damages, aggravated damages, specific damages. Okay. You can also ask. You can also sue for account for profit. So like we established earlier, the purpose of me creating a copyright work, of course, to make economic gain from it, and then the public should benefit from my content too. So I would be asking the court to give an order that the person who has infringed my work should give an account for the profit they have made by virtue of that infringement. I can also come to court and ask for an injunction for them to stop further actions on that. There is this popular Anton-Pillar injunction. This one empowers me to go to the premises where I suspect that infringement is going on and seize the master tapes, whatever they are using to do that infringement, and seize that before the court. So these are some of the civil remedies that apply, that can accrue to the copyright owner who has alleged infringement. There's criminal liability for copyright infringement.
Okay.
Yeah, it is a crime actually. It's equivalent to stealing. And stealing is a crime. So I could do a strong worded petition to the Copyright Commission and then ask them to intervene. The Commission has police powers. They have police inspectors who can go and make searches and arrest anybody if found doing infringing acts. Okay, so infringement also goes beyond just stealing somebody's work and making copies and selling and making profits. Merely importing contraband goods by way of copyright. You import books without authorization. You import pirated books from other countries. It's a criminal act on its own. The Copyright Commission can take you off on this and try you in a criminal court. So somebody can be liable to prison terms, can be liable to paying fines. So somebody can go to jail for copyright infringement. So these are some of the remedies that are available to anybody who claims that copyright has been infringed. Account for profit, damages, injunctions, and then the ultimate, somebody can be going to prison for mere copyright infringement. So I call it mere because it looks simple. You just pick somebody's book, make for the copy, and then you start selling. It is a crime. We must just leave it as bare as that. It is stealing. It is a crime and it is bad. Yeah, thank you.
Thank you so much. I'm so glad that you've touched both the civil aspect and criminal aspect, because most times people just think, oh, he stole my song, or he sampled my song without permission, or he did this. I'll just call him out on Twitter and mob action. Everybody will shout, and that's the end. I'm glad that you touched the criminal aspect and that even the police could get involved, and people can go to jail for actually infringing on another person's copyright. I think that if this were the case, if people were exploring this solution or remedy, maybe we might have moved a step further in the battle against piracy in Nigeria, because to an extent it's also borderline copyright infringements, or maybe even deep in, not even borderline now. So thank you so much. let's go to trademarks so that we don't spend all day talking about copyright. So what are trademarks?
Trademark basically words or symbols that distinguishes a business or a service. So anything that you use to describe your products in the market, anything that you use to describe your business, anything that you use to describe your brand, what you do, to describe your person, that is your trademark. So you can trademark your name, but there has to be business activity that follows that name. So common examples of trademarks are phones. Samsung, at the back of every Samsung phone, it is written there. That's
Yes.
Samsung now. So it is written. That is the trademark of Samsung company. We have HP, we have Dell. Let's take it a notch further now. We have the banks. All the names of the banks as you see them, they are trademarked with their logos. Sometimes you see the names alone. Sometimes you see the logos alone. Those things are trademarks. They are trademarked. For every gadget you see, every device, every tool you see, once you see the name on it, be rest assured that those names are trademarked. Although we talk about those who don't do trademarks, they just put the name there, they just put the logo there, and they go and speak. They have their own rights, but it's not as strong as the trademark rights. Okay, so trademark basically is that word or symbol or logo or image that distinguishes you, that distinguishes your service or your business or your product from that of others. So if anybody comes to put your logo on their product and that was not you doing it, that is an infringement on its own. So you use your trademark to determine your own line of service or your own goods in the market. Coca-Cola is there. Nobody can do a drink today and put that Coca-Cola logo on it. The moment you taste it, you would know that this is not Coca-Cola product. Okay? You wouldn't do a phone today and just write Samsung. By the time I carry the phone, I check the features, I would know this is a copycat. This is not Samsung. Okay, because we all know the value that these brands are putting out there. So the moment you see a fake, you would know. In Nigeria, we have this is very, very funny now. We have Prada, and then we have the other Pradas. Okay, we have Puma, and then we have the other Pumas. So when you see the products that come from the owners of those names, you would know, you will be able to differentiate them from the fake. Okay, so it is sad when anybody now starts using a brand name or a brand logo and start putting on a product that doesn't belong to the original owners of that. That is the point. That's that. So your trademark is just peculiar to you. It's a way of telling the general public that this is me, this is my quality, this is what I do. And it has to be different from every other trademark out there. It has to be distinct from every other. Again, we have DHL. You know that the services of DHL is just top notch. Okay, so
and expensive.
One courier company cannot open shop today and say we are DHL if they don't have a license to use it. That's another angle already now. So the trademark is peculiar to you, is a way of telling the world that this is my brand, this is what I do, and this is how best I can offer my service or product to you. Yeah.
Thank you so much. Since you kept mentioning Samsung, I think I happen to have a Samsung phone here, so you can see the Samsung. So this is the trademark. So yes. So I like what you said, the way you put it, that if someone else put it on their own product and that person is not me, they've infringed my trademark. So that's like the simplest and the easiest way to explain trademarks. But I also point out that if they are put it, one, it's not me, and I have not authorized them to do that. That there are some brands that do franchising. So other people have the right to put it, but it's not them. But it's authorized. So if it's not authorized by me and I'm not the one that put it on that product, then there's trademark infringement. I know that there are so many trademark battles in Nigeria at the moment, and even I think passing of battles. I know that I think Fearless and this other one, Predator.
Fearless and Predator.
Yes. At the moment, I believe. You're right. And then there's a Coca-Cola and Pop Cola. I think they're also in court at the moment,
And now last year, somebody sued the CBN for the e-Naira.
Okay. Interesting.
Yes, last year. Exactly.
Interesting. So
Exactly.
all these
There's a
things.
company that has their name as e-Naira and like that. And then CBN
Oh.
coming out to say they're giving us e-Naira as a means of whatever. It's actually infringement on somebody's existing name and brand. People are
Mm-hmm.
using this name, and they are, luckily for them, they are registered.
Imagine
So
that. Because I'm thinking that should they have been registered? Because should Naira not be prohibited, one of the prohibited names? Who registered
well,
them?
this is a conversation. This is a conversation for another day.
For
There's
another
some
day, for
prohibited
another
names that
day.
you shouldn't even touch at all. But
Exactly.
then we still have some of the lapses going on, and but anyways, we'll get there definitely.
Definitely. So I noticed that when you were explaining trademarks, you kept on saying that if my business, my company, this and that. So do individuals now, can they own trademarks? Or let me say, who can own trademarks? Just like we explained in copyright, who can own trademarks?
Okay, interestingly too, individuals can own trademarks and artificial bodies can own trademarks. But for an individual to own the trademark, you must be doing business with that trademark. For instance, now popular example, Beyonce is registered as a trademark, but
Okay.
Beyonce is into business.
The
Beyonce,
name, you mean
apart
the
from
name Beyonce itself is a registered
yes,
trademark? Yeah, okay.
exactly. She registered as a trademark. So apart from the music career, which is business, she has other lines of business. Okay, so this means that if you're going to trademark your name, my name is Seyi. If I'm going to trademark Seyi, I must trademark Seyi under at least one of the 45 classes of trademarks,
Mm-hmm.
which means I must be doing business with that class, that brand. So if you register a trademark in your individual name, if it succeeds and you're not doing business, that trademark can be cancelled by
Mm-hmm.
the registrar of trademarks. So this is the let me call it the requirement for one of the requirements for registration is that you must do business with that trademark. So most times it is corporate bodies, corporate entities that register trademarks, but individuals who do trademarks in their individual names, they are doing business with that name.
Okay.
Popular names, Steve Harris, popular names, Jimmy Tewe. I expect these guys to have registered their names right now because they're doing business with their name.
Mm-hmm,
You
mm-hmm.
get
Let's hope
Kule
they
Suri,
have.
and
Let's hope
all
they
these
have.
guys, I expect them to have trademarks for their name. So all the banks that you see out there, definitely they must have trademarks for all their names, for all their logos, whichever colors they come from. I was going through a chart, I think about 50 years ago. I saw how many trademarks Heritage Bank at that time that they have. In color green, it was trademarked. In color black, it was trademarked. In the
Mm-hmm.
name as it is. So, and they are using all of those things for business. So it is very important that as a trademarking it, you are doing business with it. So
Mm-hmm.
taking it a step further again, there are 45 classes of trademark. Okay, the first 36 or so are goods, and then the last set are services. So you need to put your mark or your name into one of those classes and register. So which means you're either selling a product or you're performing or you're rendering a service. Then you register your trademarks in particular class that applies to you and do business. I know some brands that registered across board, so which means you cannot register you cannot use their name to register for other classes.
Mm-hmm. So no loopholes at all. They've blocked you on all fronts.
A company now, a big business brand, can choose to register their trademarks in the 45 classes of trademark.
Okay.
But a growing business, a small business can choose to start from one of the classes, especially the class where they are either doing they have products or they are performing a service. So, for instance, pharmaceutical companies, they have their own class of trademarks, just register directly that class and they move. If their businesses are growing beyond just pharmaceuticals, they are now into shoes or bags, you can look for the particular class that applies to it and also register in that class. So the more your business grows, the more your business expands, the more registration of trademark that you need. Okay. I'm aware also that for every company that has NAFDAC registration, they have trademark. It's not a requirement for NAFDAC registration. So you must have registered a trademark in at least one class for you to register for NAFDAC.
Okay.
So all the food processors that you know, all the food processors that you know in Nigeria that are registered with NAFDAC, they have trademarks.
They are already trademarks. That's interesting. Before we go on, let me just jump the gun and ask you, do you register trademarks? So that if someone is watching this, oh, great. So please, watch till the end. I'll share his contact. If you're watching this and you need, help with registering your trademarks and all of that, this is your go-to person. So if someone wanted to register their trademark now, how do they, can you explain the process?
Okay.
Yes.
So
briefly,
trademark registration process is a step-by-step approach.
I think that we've been able to outline the fact that it's not automatically protected like copyright. So there's a need for registration.
Okay, we didn't mention that, but so
yes, that's what I want to
emphasis on it. Okay, so for trademark, you need to register it if you really want to enjoy the legal rights, legal powers that accrue to trademarks. Okay, so it is not automatic. But if you do not register your trademark, you enjoy what we call passing off. Okay, so but to register trademark now, we will check for the name you're trying to register and the symbol you're trying to register. A search will be conducted at the trademark registry to see if there will be a conflict with a pre-existing registered trademark. So the moment your name and your symbol are not conflicting with any previous registered trademark, we make application to the registrar of trademarks. That application will undergo an examination, and then within 2 weeks record time, there will be communication to you by way of letter of acceptance. So once that letter of acceptance is issued, a time frame of between 0 to 12 months starts counting, within which that mark will be published in the trademark journal. Okay, so when that mark is published in the journal, it also gives room for opposition for other persons to come and perhaps contest this mark again before the final phase of certificate issuance. So the last phase of trademark registration, certificate issuance. Okay, so starting from the search to the application to the examination to letter of acceptance to publication in the trademark journal, calling for opposition, and then to the issuance of trademark certificates. And I think I should add at this point that trademark registration is not forever. It's not forever. It has duration. Okay. So in the first instance of acceptance, the owner of that trademark enjoys 7 years validity of that trademark.
Okay.
So as the 7 years is lapsing gradually, you must apply for validation, which will last for 14 years. Okay. So for each time you renew your trademark, you enjoy a 14 years protection. Okay. And this 14 years renewal cannot continue forever.
Okay.
Unlike copyright that must go into public domain at the end of 70 years after the end of the year in which the author dies.
Okay.
For trademark, you can renew it for 14 years continuously after the first 7 years validity.
Okay.
So this is it. So for instance, when I have a brand registered in my name, Samsung for example, you don't expect us to lose that brand name, that brand image after some time. All we need to do is to renew and revalidate that trademark.
What happens if you miss one renewal in the midst of all this?
So when you miss the renewal before the trademark is cancelled by the registrar, you will get notification from the registrar to come and do the renewal. Okay. And when you fail to respond to that notice, the trademark can be cancelled, and then you have to come afresh, start all over, and register again.
Oh, okay.
So there's need to do from time to time.
And register
so you can
again.
Enjoy the trademark for life.
Oh, okay. So after you've done all the necessary renewals, you can actually enjoy it for life. And if you happen to, slip off, in between renewals.
And get counsel.
And someone can actually start a process with your name. So equity aids the vigilance in this case. And I think that's why you need it. That's why you need a lawyer. That's why, because as we're talking about trademarks, I keep thinking about, all these domain names and how, some people register domain names in anticipation, like, okay, I've registered Davido.com. The day that Davido will now realize that he needs a website, will now find that I already have it. So he has to come and buy from me, and I'll now hold him to ransom, So I think that for trademarks too, people have to be at alert. And that's why you need a lawyer. You need someone that knows what they are doing, so that they get all this covered for you. So let's differentiate between copyright and trademarks. Are there similarities, points of convergence and divergence between these two areas of intellectual property?
Thank you. So differences now between copyright and trademark. So while copyright has to do with content which you have conjured and which you have produced for us to see. Talk about books, novels, music, movies, artworks, and the like. So that is for copyright. Okay, copyright applies to those things, but trademark applies to your name and your brand image, symbol, your logo. Okay, so the protection that trademark gives is in your name and in your brand. Whereas for copyright, it is the work that you have done, the work that you have published that we can see, the work you have registered that we can touch, the book you have registered already enjoys copyright protection. Okay, but the protection that trademark gives is in your brand, your image. So nobody can come and use your brand on their own business. That is for trademark. Then the validity of copyright is different from trademark. Whereas for copyright, literary work, artistic works, and musical works enjoy 70 years protection after the end of the year in which the author dies. Whereas for trademark is valid for the first 7 years of registration and then subject to renewal of 14 years plus another 14 years ad infinitum. So long you keep renewing for the subsequent 14 years, you continue to enjoy your trademark. So in a way, we can say copyright can lapse, but trademark may not lapse so long you keep renewing. Okay. Similarities. Anybody can own a copyright.
Okay.
Anybody can own a trademark. Natural person can own trademark, and artificial person can own trademark. So a corporate body or corporate organization can own both, can own copyright, can own trademark. So like I said earlier, when the company publishes a book, when they publish a report, when they sponsor a movie, their name, they have copyright in that work. So, and then an individual can also own copyright and trademark. Similarities again. Of course, you have action for infringement applying to both. When you perceive or when you are sure certain that somebody has infringed on your copyright or trademark, you can sue. You can sue for damages. You can sue to account for profits. Of course, you can also use the other ADR mechanisms to resolve this dispute. You don't necessarily need to run to court to resolve your IP issues. But we advise that you start soft, writing a letter, and then taking the alternative dispute resolution mechanisms to resolve this dispute. What other similarities are there in these two? Of course, they are both IPs that both work on the intellect. Before you write out a book, before you write out a song, you use the head, you talked about it, and then you put something down, you work on it. Before you came about, that's your name and your brand image, logo, or symbol. It is of course some intellectual thinking or work are taking place. Before research, these days before we were able to even register companies for clients, we do some research. We search the database to see that the name we're trying to register is not going to clash with names that are already existing. So same thing applies to trademark and copyright. So you want to check that you're not registering a name or a logo that has previously been registered by somebody else. When you're designing your own brand, don't come and design your brand to make it look like Dell, D-E-L-L. Don't come around Dell at all. Create something else for yourself. Dell is already there. They've taken that name. They've taken it. Don't come and do, there's this part too, like you mentioned earlier, MJ, between fearless and the other guys.
Predator.
And Predator. They both have lions in their logo.
Exactly.
This is really a challenge. But
even
then
Coca-Cola and Pop Cola, they look so similar when you look at them.
Exactly. So it advised that you do a whole lot of research to check that you're not infringing the work of another, creating your own work, your own trademark. You just start dragging yourself into mud from your first year in business.
Exactly.
Do your business in peace and just go. Let us learn. But anyways, lawyers must intervene.
Lawyers must eat, though. Very important. Lawyers
I didn't say that. I said lawyers must intervene. I didn't say they must eat. They will eat.
And of course, lawyers can help you, prevent, and they can help you correct. Exactly. So it's whichever the best in your court, really. If you want preventative medicine and if you want corrective medicine, lawyers are at your best. So I'm glad that you mentioned the fact that don't come and model your business around existing businesses or trademarks, because I know that I think I was reading one time the decision in Niger Chemist and Nigeria Chemist, that's even passing off because they had not registered their trademark. In reaching the decision, the court held that the motive does not even matter. It doesn't matter if you were trying to be malicious or not, but if it is similar enough to an existing trademark, you're already passing off. So it's important for you to involve a lawyer. He said that they do all these checks for you, at the initial stage to see if you're not clashing. So it's important for you to get a lawyer, a professional, to do these things for you. So if I find out today that my trademark has been infringed upon, what do I do? Advise me, okay, lawyer.
The first thing, which is a very, very good one to do, is to write a letter to that person.
Okay.
Other actions on this list. I can be kind enough to show you my proof of registration, that I have a registration for this trademark. So please, in your own interest, stop using my brand name or my brand image. That's the first step. So the moment you fail to respond positively, as advised, come on, man, we can find ourselves in court the following 2 months. I can be suing for infringement of trademarks, and I can be asking for damages, serious damage, because the moment you use my name or my brand image and put it on your product or service, you're trying to tell people that it is me that is offering that product or service, whereas it is not me.
So that's fraudulent.
Unfortunately, it could be offering substandard products and service to the public. Before they say, when you start making fake items, offering fake services, well, it's not me.
This is very important. This is very important.
Business for me. Exactly. So you using my name without my consent is spoiling business for me. At this point now, let me not say that there are valid ways within which somebody can use the brand image of another person to do business. I could license you to use my brand name and image to do business. For instance, I want to believe that not all Chicken Republic outlets in Nigeria are owned from the guys in the US. From Kentucky.
I think it's a franchise.
Exactly. So I can license you to open an outlet in this particular place. So there's something you're paying me in return to use that name, use that brand image. However, there are standards that you must adhere to.
Exactly. That's what I wanted to say.
You cannot adhere to those standards. Please just close shop. Don't come and spoil the name. Chicken Republic is a name that is so valuable. You cannot afford to offer substandard service to people. When people come to your own outlet because it is licensed, you must, as a matter of importance, offer the same service as it's offered in every other outlet that are using that name or that are owned by the original owners. So when you use somebody's brand to do something, make sure you are licensed to do it. Okay? Or don't even use that license. You don't even use that person's brand at all. It's infringement on its own.
Okay. Thank you so much. So I know that this is deviating from the line that we're following, but I really want us to just shed a little light I have just a few questions and we'll be done with this session. But
Right.
because I just remembered as you were talking about Dell, like don't use DELL. I remember that, there's a Weezys, I think it's Nike's sneakers, and then there's Yeezys by Kanye West. So that's similar. They're not the same, but they're similar. So I wouldn't know how they came about that. I'm not really sure I read so much about that. But I know that there was a point when Kanye West was trying to register Sunday service, the words Sunday service, and it was denied by the patent office, that's like a generic word. People have been saying it even before you were born. So you cannot just corner it and now say you are the one making that, because I want us to understand that, the importance of either trademark, copyright, or any of this intellectual property is to exploit it economically. So now you cannot hold people to ransom that you're the only one that can make profit off the phrase Sunday service. So are there things like that? Are they prohibited? I know we've touched on it, but maybe just shed a little light on things that you cannot even go near these marks or these names or this color or these signs, what have you, for trademarks.
Okay, so definitely there are prohibited names that won't be granted when you apply for registration. For instance, personally, we don't expect anybody to be granted registration for e-Naira when they did. But don't forget that e-Naira has been registered as far back as 2010, or if not earlier than that. So it's been a long time coming.
A long time.
Then they didn't come and say Naira alone. They put E in front of it. So perhaps the examiner felt there's already a difference between Naira and
Naira. Okay.
But if you go in the Palace of Corporate Affairs Commission, there are some words that would automatically bounce once you come. They shouldn't give you Naira. They wouldn't give you words that are just peculiar to perhaps the nation's heritage.
Okay, like Nigeria.
Exactly. So if you are doing Nigeria, it is generic Nigeria Limited.
Or Super Eagles. Okay. They should give me Super Eagles.
Don't come and want to own what all of us own already.
Okay.
Don't come and personalize.
So that's the rationale.
Don't come and personalize a national heritage and say it is yours. It won't be granted to you. So some names should not be granted. I'm trying to wrap my head now around some other examples, but they're not coming. But Naira as a name, you wouldn't get it. So what the Naira guys have done is to add the letter E to the Naira. I remember that I think 2 or 3 years ago now, I started a company for a client, and the first name there was Naira Me, Naira ME. I remember very well. I'm so sure that if Naira was the sole word in that name,
okay,
granted. So Naira Me distinguishes it from Naira. The ME at the prefix now, the suffix rather at the back of Naira takes it off the sole word Naira alone. So we're just saying that some names would not be registered and should not be registered because they belong to all of us. I remember also either last year or 2 years ago, some guys registered was it copyright or trademark for Yoruba?
Yes, Yoruba name.
Exactly.
No, was it even Yoruba name? I think it was something Yoruba, something, not Yoruba name, because I know Yoruba name is Olatubosun. This one was like a foreign company. I remember there was
foreign for that matter.
Yes,
foreign for that matter. So there was an uproar, and eventually that registration was taken down. So these are the things we're saying. So something is peculiar to the community. Don't come and personalize.
Exactly.
Don't come and personalize. So we know that Gari Jebu is for the Ijebu people. So don't come and say you are the only one making Gari Jebu. You can't come and trademark. You won't get Gari Jebu for trademark. You must find something else that distinguishes your own Gari Jebu from other Gari Jebus. But Gari Jebu, as the phrase on its own, belongs to a particular geographical location. That is geographic indication for that people, for them in Jebu. So you wouldn't get it all to yourself. We all know where the Gari Jebu is coming from. We know the people that make it.
Exactly, and we know the standard, the quality.
and not own it. Yes,
Mhm.
exactly. So some names will be prohibited from registration because of what they connote. Exactly.
Okay. So I like the fact that you have answered this question in two ways. Now, you've said that one, you've thrown some light on the prohibition, but you've also made us understand that, if you want to, there's a way to go around it. Like, you could add some things and all of that. So I think that that's the essence of a lawyer. Because my next question is, what's the role of a lawyer in protecting copyrights, protecting trademarks, intellectual property in general? What is the role of a legal practitioner in all of this? So before you answer that question, I'll just say that from your last answer now, I can see that the first, one of the rules is that even where there are clear prohibitions, and you need something for your own personal brand of business, a lawyer will know how to go around it so that you do not offend the rule and you still get what you want at the end of the day, just like the e-Naira and Naira examples that you give. So please answer the question. What's the role of a lawyer?
The first one is counsel. The moment a client comes to your desk and say they want to register trademark, for example, I would ask them to write the name of the trademark or the name of their company or the name of their business. And then I would ask for the soft copy and an impression of their symbol, of their logo. Okay. So when we see those two things, I'll now the lawyer should now inform them that there is a need to conduct a search on existing registered names and symbols to be sure that there is no clash. Because if there's a clash, you can't proceed with that registration. It won't be granted. So the lawyer would counsel, would advise, would facilitate his search, and then the lawyer would go ahead and apply for registration. The lawyer would go ahead and apply that certificate is issued at the end of required time after publication in the journal. So the role of the lawyer is to, of course, to take care of the legal process and the registration process that follows securing that IP. So the lawyer is also there to ensure that remedies are obtained when there is an infringement. So, for instance, somebody's copyrights are infringed on, you should inform a lawyer about it.
Okay.
The lawyer would know what to do. The first step ordinarily should be to write a letter. You're either asking them to desist or even asking for damages straight up from that letter. And then you give it the threats of litigation or ADR. There are mechanisms to resolve that is seen already. So the lawyer would help you to, of course, we call it obtain justice. Yes, obtain justice for the damages suffered in the course of that infringement that you have seen. So a lawyer would help to prevent infringement, and the lawyer would also help to obtain justice, as in get damages for infringement suffered by the owners of copyright or any form of IP whatsoever. Exactly. Then a lawyer also helps to register the IP of their clients. Yeah. I think these are basically the roles of the lawyer, apart from the tougher ones that may arise that I don't know. Yes, of course, the lawyer also helps to draft intellectual property agreements, licensing agreements from time to time. So, for instance, of course, a new Chicken Republic wants to open my street, and somebody feels I have the financial capability to obtain that license from owner. So a lawyer would be involved in drafting that licensing agreement, perfecting it, and ensuring that all parties are well taken care of. So a lawyer helps in drafting and proofreading and all of that.
Thank you so much for your response. So finally, I want to ask this question because, I said at the beginning that the channel is for law students and laymen and lawyers. So I know that our practice in Nigeria is more of a general practice. And most people that specialize, they have to go out of their own way to carve that niche for themselves and to retrain themselves. So I know that, for instance, there was no such course as intellectual property law in my own school when I went to school. I know that everything I know about intellectual property law today, I deliberately applied myself to it and took out time to go for trainings, to take courses online, to read up, to learn on my own. So if someone wanted to be an intellectual property lawyer, just like you today in Nigeria, where do they start and how do they, where do they start? How do they train themselves or retrain themselves? Even if maybe they're a law student or they're already a lawyer, but they want to go in intellectual property, they want to carve a niche in that direction. How do they go about it? Or maybe how did you go about it, and what advice would you give to someone looking to that direction? So that's the final question.
I like to answer this question by using myself as an example. So I was opportune to offer IP course in my 300 level. I was university, and I was in 2010. So I did IP in the first semester. So we did copyright in that semester. We did trademarks in that semester. I think we did a bit of no, just copyright and trademark in the first semester. Second semester was supposed to be for patent and industrial design. I didn't offer IP as a second. So I had my first shot of IP in 2010. While I was writing my LLB thesis, I wrote on copyright. So I was able to solidify my brief interaction with copyright in my third level in my final year. So I wrote on copyright. I kept it in my left hand. So from 2012, the next time I had interaction with IP on a large scale was 2016-17 when I started my LLM. Okay, so I just bundled myself and went to focus on IP in my LLM. So which means I offered IP courses full-time for LLM, and I wrote my thesis again on IP.
In Nigeria?
Nigeria, yes.
Interesting.
Nigeria. So I can say that beyond the first experiences in 2010 and 2012, I resumed again to reading more about IP in 2016, 2017. So I did LLM in IP, I wrote a thesis on IP, and I've been servicing clients in IP since 2017. I've been involved in copyright and trademark registration since 2017. So I have one or two things to do with IP. I have to refresh myself, attend to a client's need or question on IP from 2017 to date. I create content also on IP. Okay. So for those who want to take an interest in IP today, if they are lawyers already, they can start like NJ started by reading. I can suggest one or two books that they can actually go and start with. And then there are courses that can help. There are a lot of courses on WIPO today. WIPO.
That's World Intellectual Property Organization. Exactly. They are taking WIPO courses too. I think WIPO is like the starter course for everybody. I've taken 2 courses on WIPO myself.
Great. So there are a plethora of courses I can take on WIPO. I can help you come up in IP. But before taking the course, it is to be nice for you to read books. There are Nigerian authors, fantastic authors in Nigeria on IP that I can refer you to. While I was in undergraduate days, the books I used in university for LLB was Papa Femi on IP. But in my master's class, I used Adejoke Oyewumi on IP.
Okay.
It's a beautiful book on IP. It will help. It simplifies copyright, trademark, patents, and designs into bits you would understand. So all you need to do is to put your mind to this book and read. And when you finish reading, you can start asking questions from perhaps other IP experts that you know. Start creating conversation, discussions about IP, like we're having with MJ today. You can call a friend, 2 or 3 or more, and just discuss IP. From there, your knowledge of it continues to grow and increases. Okay, so and then when you start studying, try to put out content on your space, on your social media. If you're going to focus on IP, it's not by force anyways. If you really want to dwell much on it, you should let us know the things you know about IP. So go on your social media space and teach us 2-3 lines, one Canva design or 2 graphic designs, drop it there, call for engagement, and it will pour you into further research. Somebody may ask a question that throws you off your feet, and then you go into further
You go and
research, and
research.
then before you know it, you are knowing more. The good thing about
Exactly.
what you've done today is that some of the things we have said today will stick here forever.
Mm-hmm.
They won't go because you don't only know it, you have expressed it, you've shared it, you have mastered it, you have owned it. That is the joy of it. So you take courses online, and then you can actually take an LLM like I did. Not bad. It's not bad. And then you can teach IP. Teaching it helps you to master it. You can teach it to undergraduates, you can teach it to the general public. Like I said, on your space, you can go on Insta Live, you can go on Twitter space, talk about intellectual property. Somebody will learn from it, somebody will engage you from it. Before you know it, you're creating a name for yourself, you're creating a niche for yourself. And then before you know it, you're an expert. And you don't need to know all to become an expert. That one that you know, that is it that you know, just master it. Continue to develop and grow more into it. And you are there already. It's not perfect. There's no big deal. I didn't sit down one day and say, by force, I want to master IT. Just started gradually.
Mm-hmm.
Here we are today.
Wow, thank you so much. This is you've just done is like a speed mentoring session for people who want to go into IP law. Honestly, because I can relate to most of these things you said. For instance, I said that there was no IP course in my university. So it was after university that I decided to start learning about IP myself. I took courses online. I took a certificate course offline in Lagos. Then I know that I started reading, I started writing about it, like you said, putting out content on IP. Then I did an internship with IPLAN, Intellectual Property Law Association. I think you're affiliated with the organization as well. So please, if you're watching this and you're looking to go into IP law, since it's you might go its own route as well and do maybe a master's in, what university did you do your master's in? I know I've read it in the beginning. From your mouth, yeah. Yeah, Nasarawa State University, Kefi. So you could also take an LLM program in intellectual property law, but the field is so wide and there's so many opportunities. You know that in this session, we've only talked about copyright, we've talked about trademarks, just 2 branches, and look at how long we've spent, and we have not even, touched, we've just been on the precipices of, those areas of intellectual property. So it's all about training and retraining yourself if you are watching this and you'd like to go into IP law practice. And if you need the services of an IP lawyer, we have our very seasoned IP lawyer here, Mr. Seyi Arowosebe. So I want to read out his social media handles now for further connection. He's on Medium as Seyi Arowosebe. Yeah, I'll put it on the screen. He's on Instagram as Seyi Arowosebe. Yes, that's consistency. He's on Twitter as Seyi Arowosebe. Same thing. He's on LinkedIn as Seyi Arowosebe and on Facebook as Seyi Adedeji Arowosebe. So do well to check them out. You can contact him, take the conversation further. And if you have a brief, an IP brief, or if you need the services of an expert, is your go-to person, you would be able to decide for yourself, based on what you've heard here today. So thank you so much, our special guest of honor on this second episode of Podcast with Ola. I'm so glad that, you could come, and I'm so happy for things that we've talked about, especially because you've talked so much about the remedies that are available to people and the procedures for actually securing these rights, not just about going to social media and shouting, calling people out, and then everybody will shout for 2 or 3 days and move on. So it's not so much about that. And I think you mentioned one area of ADR. I'm a mediator, so please, if you have a clash, if someone has infringed on your IP, like he kept saying, write a letter first, explore ADR, you can get an ADR facilitator like a mediator or, a negotiator. I don't know if arbitration covers that, just an ADR person or a lawyer, to mediate, to do ADR for you before you head to court, I remember that in this movie, what movie is that? Your Excellency. I know that, there was an artist whose song was used for a campaign jingle without his permission. And then they met, he and the politician met, and they discussed instead of going to court, and he was able to get some settlement, and he became even the official singer for the campaign. So, ADR can be explored at all times for intellectual property infringement. So we are going to put a pause on the program or the session for today. Thank you so much, our guest, for coming. And thank you all for watching. We will see you in our very next podcast. Bye.